Hello, good morning, everyone. Thank you for joining us on a Saturday morning for the third annual SLR workshop. My name is Jyotika Tomar. I am the present editor-in-chief, and I hope this is a useful and productive way of spending your Saturday morning. So we'll just begin. So on the agenda for today is an introduction to SLR, our mandate and our scope, which will be followed by a presentation by our keynote speaker for today, Professor Anindita Adhikari. This will be followed by a discussion on the circulated papers that we sent out yesterday. These are Deepadas Acevedo and Janvi Chamarti's paper, Cultivating Attentiveness to Law in India Through Legal Anthropology, and a paper by Samina Dalwai called Dance Bar Ban, Doing a Feminist Legal Ethnography. And our focus for today's workshop is largely going to be questions of positionality and method when it comes to doing socio-legal scholarship and research and fieldwork, focusing specifically on legal anthropology. After this, we'll have an open discussion and a question answer session where we welcome you to raise any comments or thoughts you have, questions you have. We will then come to a segment where we want to discuss avenues for publishing social legal work besides SLR and the broad community of social legal networks and scholars where we find ourselves. And finally, we will offer some guidance on the process of submitting to and writing for SLR and discuss our editorial policies and submission guidelines. First, to introduce our keynote speaker for today, Professor Anindita Adhikari. She is an assistant professor of social sciences at the National Law School of India University. She received her PhD in sociology from Brown University and was a postdoctoral fellow at the University of Michigan. She also holds prior degrees in development studies and political science from the University of Sussex and from Lady Shri Ram College, University of Delhi. Her research interests include social movements, bureaucracies, the politics of welfare provisioning, and democratic deepening. And her research and teaching is informed by about 15 years of public action work with the right to work, right to information, and right to food campaigns. She has previously worked with the government of Bihar and the Ministry of Rural Development as well. In 2022, she founded the organization called Social Accountability Forum for Action and Research, or SAFAR, which works on strengthening transparency and accountability in public delivery in collaboration with state and national governments, as well as civil society. Presently, she is working on her first book project, which is titled From Shikayat to Jawabdehi, which examines the effects of rights-based welfare expansion and its effects on local governance and civic action through a comparison between two institutionalized accountability systems in Bihar, which is what she will be drawing on for today's presentation as well. Just to introduce the journal and our mandate, the Social Legal Review is a peer-reviewed biannual journal that encourages interdisciplinary research at the intersection of the law and the social sciences. We are open access, student-run, and published by the NLS at Bangalore. And we are this year into our 22nd year of publication. We were established in 2005 with the help of a grant from the Modern Law Review. And over the years, we have carried articles by several luminaries in the field of law and society, but also increasingly several early career academics and graduate students as well in recent years. On two instances, we've been cited by the Supreme Court of India in Justice Chandrachud's opinion in the Puttaswamy judgment, as well as by Justices Indu Malhotra and again Justice Chandrachud in their opinions in the Joseph Shine judgment. Along with our print journal, which is published twice a year, we also publish shorter pieces on our on our online platform, the Socio-Legal Review Forum, through which we want to focus on accessible and timely discourse on issues of social legal relevance. On our aims and scope, we subscribe to an expansive view of law and society, and we want to publish scholarship that goes beyond looking at the law as merely a set of rules and doctrines and welcome interdisciplinary research, which critically inquires into the intersections between the law and the social sciences. And to give you a sense of the areas and disciplines we have worked on over the last few years, these include a broad range of disciplines and themes, including ethnography and anthropology, legal history, perspectives towards the law and society, which include decolonial, post-colonial, class, feminist, queer, and class, and work with the education pedagogy and theory, as well as themes including identity and migration and citizenship studies, environment and urban studies, religion and minority studies, bioethics, disability studies, and so on, as well as work on civil society, human rights, socioeconomic welfare, criminal law, and law in the humanities. And our next issue is incidentally a special issue on law and culture. We also want to draw your attention to the SLR reading list, which was sent out as a part of our invite yesterday, which is a curated list of resources on ways of better understanding the socio-legal as a category generally, as well as a broad state of the field reviews on what the state of scholarship looks like, as well as curated pieces from the SLR archives themselves, curated along themes and disciplines. So we encourage you to have a look at this for a better sense of what socio-legal is and where we stand. So without further ado, I want to just hand over to our keynote speaker, and I will just share the screen accordingly.
Thank you, Jyotika, and thanks everyone for joining on a Saturday morning. I think this is just the audience that one wants to have, which is you wake up on a Saturday morning and want to talk about socio-legal research. So this is my crowd. This is great. Thanks so much, Jyotika, Abhinav, and everyone associated with the SLR. It's really one of the most dynamic and exciting student-led, student-run initiatives on campus. So I always, even as faculty, look out to see what you're reading next and what your reading circles, the kind of conversations that your reading circles are generating. And so it's really an honor to be here and to participate in this workshop. So thanks for inviting me, and thanks very much for your very, very thoughtful questions on positionality and attentiveness, which I just put into the title because it made me think about my work and think about the method more explicitly in a way that I hadn't done in a while. So it's a nice opportunity to revisit my work through this lens. So with that, I just thought I'd take about maybe 10 or 12 minutes to just talk a little bit about my work and share some excerpts from the research to give everyone a little bit of food for thought and some questions that I hope they generate. So we can turn to the first slide. Yeah, the next one. So yeah, the one after that. But yes, perfect. So this is just a kind of a quick map of the kind of terrain, the legislative terrain that my work engages with, which starts in the early 1990s, where rights-based legislations were sort of beginning to take shape, and trace their origin story to popular mobilizations, such as the Right to Information movement, the Transparency movement in rural Rajasthan. And then we see a slew of different rights-based legislations from the early 2000s all the way up to 2015 or so. And then of late, everyone who's been following the news would have been following how, the dismantling of one of the flagship rights-based legislations of this time, the National Rural Employment Guarantee, is now we're beginning to see this timeline perhaps take a slightly different turn. But my research focuses on this 15 very productive years of rights-based legislation making, where we see that India introduced rights-based legislations which then guaranteed various social and economic rights, from the right to employment, food security, and primary education to over 80 crore people. And importantly, a foundational right to information law, which is the right to ask for information that doesn't just pertain to these socioeconomic rights, but to governance more broadly speaking. So given that this is the legislative landscape that I focus on, you can turn to the next set of slides, Jyotika. The scholarship on rights-based claim making in South Asia, I find, tended to be divided or clustered at these two ends, so the two extremes. So the socio-legal literature in South Asia, but also more broadly, tends to focus predominantly on pleas to courts, which I call claiming from above. So the fulfillment of these rights or redeeming these rights, the focus of the institutions, the actors, the sites where these laws are studied tend to be clustered at these two ends. So one being, images of courts like this would dominate, where scholarship on the fulfillment of even seeking accountability from the state would largely be confined to sites like the ones you see here. You can click through the next three. Where you'll see ordinary citizens approaching the courts for and petitioning the courts through various means. Yeah, we can go to the next one. And yeah, whereas the scholarship that, no, the one before this, whereas the scholarship that looks at more local practices of claim making, which is at the other end of the spectrum, focuses quite overwhelmingly on the role of informal institutions. So looking at the role of brokers, looking at the role of party workers. So you see seminal work, and these are mostly by political scientists, but also by anthropologists that tend to focus on brokers and intermediaries or party workers as giving access um, uh, to either guaranteed benefits or other kinds of entitlements and public services. So what we see is then this clustering of formal claim making dominated by courts at one end and informal claim making dominated by brokers and intermediaries at the other end. The next slide, please. But claiming from the state, which I have focused on over the last 15, almost 2 decades now, can also look like this. We also see now an expansion of various other sites of formal claim making, which you'll see in the form of these counters that you see on the photograph on the right, which followed the introduction of right to public service laws, which are now in place in about 22 states across the country. This was just one state in the early 2000 in 2009, and today most states in the country have a right to public service law, which has been accompanied by this expansion of infrastructure of the state at the local level. You'll see information and facilitation centers like the photograph on the left. The next slide. You'll see windows like this, which receive applications for all kinds of benefits and entitlements like pensions, or it could be service-related requests. It could be demands for documentation like caste certificates, so on and so forth. It could also look like, you could flip to the next one. Sometimes these physical counters look like this. You also have online and offline modes of petitioning governments. So here you see an encounter between a complainant or a claimant, a citizen, sitting across a grievance redress officer in the state of Bihar. It's a case that I'll focus on in just a moment. And you see the implementing authority, the smiling man on the right, who is a block development officer that is also sitting alongside the complainant or the claimant as they are negotiating the distribution of a drinking water infrastructure pipeline that had to be laid in his ward. You can go on. So sometimes these sites could look like those individualized hearings. Sometimes they could even take the form of collective hearings, like the one you see on your screen now, which is part of a process of people-led audits, which were also embedded into several rights-based legislations, prominently the National Rural Employment Guarantee Act, and it continues to remain intact even in the new act that has replaced the NREG, and I'll talk about this more in the Q&A if anyone's interested. You can go on to the next one. We also see formal claim making look like this sometimes, which is when actors from the state, they may look like paralegals. In this case, these are actually social auditors who are verifying public records and recording testimonies from citizens when entitlement claims have not been met, or when citizens have petitions or demands to make of the government. Sometimes it can look, and the next slide, please. Sometimes they can be held at the doorstep of citizens. Sometimes the state then enters more public places where citizens can gather, where they arrive the doorstep of citizens or they arrive in public spaces to verify the performance of public programs and register claims. And this, for example, today, sites like this are quite common across the country. You can see initiatives like this mandated by law take place in about 70% of 250,000 panchayats across the country today. So the scale and the sheer expansion of this infrastructure of the state, where formal claim making is being done and engaged with on an everyday basis, it has been quite remarkable in the last 2 decades or so. And the next slide, please. And sometimes these encounters can also be within government offices, like a block development officer's office. This is a citizen, a pensioner whose widow pension claim has been delayed for over 2 years, and who's confronting this block development officer directly in his office. So all of these, to the next slide, please. So all of these images kind of hopefully bring together what the very terrain of formal claim making in India looks like today, beyond the courts, beyond petitioning, and beyond the judicial system. So I study the working of one such formal forum for claim making and grievance redress in the country, which is in Bihar. I look at Bihar's grievance redress law, which was introduced in 2015, which was a legal right to redress. And in my work, I argue that what formal claim making forums like this do is that they've expanded the infrastructural power of the state. They've invited new challenges to the legitimacy of the state. They've opened up the local state to the possibility of democratization. But it is also it's also an interrogation into how legalized forms of accountability also open up new possibilities for thickening association life, how people collectively organize, mobilize, and how it incentivizes more claim making and assertion of one's democratic right to participate in decision making, make claims, ask questions of the state, and so on. So the two questions that I ask in my research is how are forums for legally backed participation and citizen oversight built in very centralized bureaucracies that have historically been allergic to transparency, and how do they then embed themselves in deeply fragmented contexts that are really ripped apart by divisions of caste, class, gender. Why does rights-based claim making even emerge through these formal forums, where we would expect disenchantment with the state, where we would expect disenchantment with the law? So I use a range of different methods. Since this is a session on methods, I do want to spend just a second explaining that to arrive at, to be able to study these sites, and to build attentiveness deliberately, I use a range of different methods. I did about 80 in-depth semi-structured interviews with bureaucrats at different levels, grievance redress officers, citizens that file claims, activists and lawyers, brokers and intermediaries as well, who sometimes hang around these sites and public institutions and offices. I also sat and observed grievance redress hearings in 4 districts, and I did the same for social audits and the more collective form of hearings. I also looked at the text of 60 complaints filed under this particular law. And importantly, I was also involved in a reform process in Bihar from 2010 to 2012, and continue to remain embedded in the campaigns and movements that have fought for some of these legislations in the past, and continue to monitor the everyday implementation of these laws scattered across the country. And I'll talk about that briefly in the Q&A. So now just wanted to shed a little bit of light on the part of my research which looks at the law in practice. So we have this grievance redress law in Bihar in introduced in 2015, but to be able to, which set the terms of what is considered legally grievable. But in order to really understand how this law is working in practice, what are the pathways to receptivity, how is redress really constructed, I focus on the site of the hearing itself. And here I go beyond the completeness of the resolution or the recorded satisfaction of the complainant and look for other outcomes of the hearing process. So for instance, I look at whether testimonies and evidence of the complainant challenges power of the local state and dominant elites, whether hearings unsettle the local political settlement, and how these claim-making encounters shape the perceptions of everyday practices of bureaucrats who participate in the hearing. So I'm not just focusing on how arguments and evidence are brought to bear on the case at hand, but to really pay attention to the kinds of narratives and counter narratives that are constructed during this encounter. But in order to arrive at those modes of listening and attentiveness, I create this sort of I'm attentive to these three factors that shape that claim making encounter. So the first are professional identities. The second is the type of the complaint itself, and the third is the background of the complainant. So in terms of professional identities, I identify three different ways in which the grievance redress officer, the man sitting on this side of the table, approaches the law himself. What is the grievance redress officer's disposition towards the law? And here I find that there are about three different kinds of grievance redress officer dispositions. One who sees themselves as a safety valve, as letting, where citizens are allowed to let off steam, and that protects the state from kind of wider or deeper forms of disgruntlement or discontentment. The second is where grievance redress officers see themselves explicitly as people's representatives, and the third is where the grievance redress officer, who's really drawn from the bureaucracy itself, is unable to disconnect from and create positions of independence or autonomy from the grievance, from the bureaucracy, and sees themselves predominantly as sympathizers. The next slide, please. So in terms of orientations towards the law, these dispositions then direct orientations that these grievance redress officers build towards the law. So one is where they begin to see the grievance redress law as nothing but a capacity constraint, an overload on their everyday work. So a quote like this, for example: "How has the grievance law redressed strengthened our capacity? It's like giving us a small bow and arrow and sending us into the battlefield of the Mahabharata." That's one way in which grievance redress officers perceive their work, and also how these grievances will then be received by implementing authorities. Some look at the complainant as politicized. They see these complainants who approach the state to file grievances as nothing but theaters of expressing personal vendetta, or trying to accrue some kind of individual benefit through this institutionalized process. However, there are others who will identify openings that the grievance redress law has introduced, and they will turn to phrases such as "the rule by obfuscation" or "Tal Matol ki niti" has actually weakened when this grievance redress law was introduced. So we hear these different kinds of orientations and dispositions towards the law. We can move on to informal taxonomies. Yes. So similarly, these grievance redress officers will also categorize complainants into political and genuine complainants, which will then influence the way that they conduct the hearing, the way they weigh evidence, and the kind of resolution orders that they would also provide. So some would see complainants as public spirited, some would see complainants as political, some would see the complaints themselves as either resolvable, and some would see complaints as lying outside of the purview of the law itself, in which case the way the hearing would be conducted would not allow for much of a narrative or counter narratives to even be aired, because the grievance has been closed before it can even be heard. So this is how dispositions, orientations, and these taxonomies will shape the actual encounter of the hearing itself. Next slide, please. Yeah. So very quickly, I just wanted to share one case, and then we can open up for questions, which is that this is the case of Kulpatya Devi. Kulpatya Devi's hearing took place before the only woman grievance redress officer I encountered during fieldwork. So you see this in front of her. You see these two plaques of which say Parivadi or applicant and Lok Pradhar or official authority. And the block development officer entered was already seated. The complainant enters the room. She's from the Sahni community. She's a widow, she's not. This is the first time she's actually entered an administrative office of this kind and been seated with a designated place for her at the table. So the grievance redress officer asked Kulpatya Devi to take the seat next to the block development officer and explain her case. And Kulpatya Devi is very hesitant. She takes her seat and she pulls the sari that's draped over her head even tighter till it actually almost covers her face. And the grievance redress officer remarks quite sharply, saying ki kapda hata kar boliye tab to sun payenge. So asking her to do this, of course. But Kulpatya Devi then obliges, and she says, I received my widow pension once in 2017, after which payments stopped. The grievance redress officer says, why did you wait for so long? You will not get the backlog of payments. You should have come here sooner. The BDO also pipes in and says, I checked in my office and we don't have any papers on her. Now, this is what really enrages Kulpatya Devi, who now raises her voice and says, I don't lie. Shoot me if you want to, but when I speak the truth. So the BDO then retreats and says, okay, she must have stopped receiving her payment because her Aadhaar card and bank account have not been linked on the portal. Come and meet me in the block tomorrow. Bring your Aadhaar card. Your work will get done. Kulpatya Devi resists and says, no, I have come multiple times. My work has not been done. The BDO, on the other hand, says, provides one excuse after another. But at this point, the grievance redress officer intervenes and says, it looks like you have no control over your staff. Have you organized a camp to sort out these issues? This woman has been declared dead according to your records. Get her certificate made and signed by the panchayat secretary. Immediately show me the receipt. Submit the papers for correction in the portal. This is your last warning. So again, we see a hearing of this kind unfold with think about the various dispositions and orientations to the law and where this grievance redress officer would fit and why this hearing unfolded in the way that it did. So again, when I checked back in on this particular case about 2 months later, I found that the claim had actually not been resolved. Kulpatya Devi had not received her pension, but her Aadhaar had been matched to her bank account, and there was the intent or the payment delivered was on the cards, as the bureaucratic kind of obstacle had been cleared, but the pension had not been deposited. Now, one could either dismiss this case as one that it was not resolved, this was an unsuccessful attempt, this was an incomplete resolution or a failed resolution, and we could dismiss the hearing itself as not doing much. But if we pay attention to the kind of dynamic that we see unfold within this bureaucratic office, we can see that we see an assertion of a democratic right to know, to ask, to claim. We see a leveling, even if it's temporary, a leveling of power momentarily within the grievance redress officer's office. We see a block development officer having to retreat and also go back to records that he would have otherwise have perhaps kept suppressed. We have a Kulpatya Devi who now has a paper trail or an incentive to perhaps pursue her case again. So what we then see is in cases like Kulpatya Devi, but also several others, the 60 others that I track in my research, we see that there are varieties of redress. So the last slide, and then I'll pause, is that what this kind of attentiveness and what this way of looking at the law outside of or looking at the law and how it works in formal claim making forums, but outside of courts and formal petitioning, also opens us up to the possibility of varieties of redress. So here I am attentive to not just resolution of the complaint in terms of the actual letter of the entitlement of the law, but also whether the hearing itself allowed for any kind of disruption to take place. So I then categorize the outcomes into those where we see resolution, but we see resolution, we see no resolution, but we see some form of disruption. We see disruption sometimes without resolution. We see no resolution and no disruption. So our expected kind of outcome in most of these cases, and most scholarship that studies these claim making forums, which are very limited and thin, tend to look at outcomes in these binaries of where we either see an outcome that is fully resolved or one that is not resolved at all. So no resolution, no disruption is what what we anticipate the outcome to be, but what these modes of listening and attentiveness in studying the law in these kinds of sites and institutional spaces opens up the possibilities of two other kinds of modes of forms of power being disrupted, even if it is temporary, even if it is temporary. So I'm going to pause here. There's a lot more, but I just wanted to give a little bit to open up and give you all something to dig into. So thanks for your patience.
Thank you so much, Professor. That was incredibly rich, and I'm sure it's opened up many lines of questions and possible ways of thinking about social legal research. I will now hand over to our editors, Hiranya and Ashutosh, who will lead the discussion with you and also on the papers that we circulated. And we will come to questions from participants right after that. So I would request that you hold on to your question right now. And when we come to the question answer segment, then you can either unmute and ask or you can put your questions in the chat. But over to Hiranya and Ashutosh. This is, yeah.
Yeah. So thank you, Professor. That was very interesting. And I have lots of questions about the research itself. But just taking a step back and thinking of the entire field again to discuss your methods, to discuss how a sociologist engages with social legal work, let's begin by understanding your opinion or your understanding of what positionality in your own work as a sociologist has been by training as you move across different research sites and themes. For instance, you have worked in the case of exploitative regimes, you've worked in welfare governance, you've looked at migrant labor during COVID-19. Across these research sites and themes, how do you understand positionality? Do you believe that it is a function of, let's say, your own biological identity makers, such as caste, class, or gender? Or do you believe it's about the institutional location? That is, say you're coming from a particular institution, you're a scholar of a particular institute, and how does this impact your own work across these themes?
Yeah, thank you. So positionality was critical. I think firstly, my research questions would not have emerged unless I had had the prior experience and embeddedness in these movements for at least a decade before I actually started the doctoral work. So one is that what leads up to the question shapes the nature of the questions that you're asking itself. The second is that when you're doing research, there are, of course, your positionality is shaped by your identity markers, of course, which will determine, which may either limit or open up access, and that interacts inevitably with your institutional location as well. And institutional location for some could be just, your academic, where the institution, literally the institution you come from, or which institution you are perceived to come from. So in my case, they sort of, I think they were both important and they both interacted with each other. So for instance, if biographical and identity markers potentially limited my access in some cases, being a woman, being a younger woman at that time, especially, and I would often be confronted with either, condescension or silence, sometimes even stonewalling. Then my institutional background of having worked with state governments and the national government before undertaking this research was often flipped things for me when I was trying to access or to be able to speak, particularly when you're studying up. I think as researchers, and this is where the Dalwai piece also talks about what it means to do, what does feminist ethnography do, which is that you're not just studying down, but you're also studying up. You're studying those in power, or those who are setting the terms of that engagement between citizens and the state. And that's where the stonewalling tends to happen much more, right? So how your then identity markers interact with your institutional backgrounds, and how you bring that to bear reflectively, because you're aware, you're constantly, you must be constantly aware of what you are using when, and why access may be blocked and why access is opened. So that is something that I do take care to write about in in setting up any findings from my research in the manuscript or in any articles that I do right. So again, it also shapes then the not just the data collection process, but also the data interpretation process. So just to give you an example, I did share very close ties with activists and grassroots organizations that were involved in the introduction of these and the design of these rights-based laws since the early 2000s, and I've volunteered with several of these campaigns. So again, I didn't deny it or bracket it as I conducted this research, but I brought those associations in to also thinking about the research collaboratively, which we can turn to in just a moment. So again, using this embedded approach to ethnography, where the ethnographic, the epistemological, which is what does it mean to even know something, and the political was explicitly not kept separate, but was actually brought together in doing this research. And I'll explain a little bit more about what that means when we talk about collaborative research and what that looked like in this case.
Thank you for your answer. So, as I understand that your work has incorporated both influences, who you are as a woman, a young woman, as well as the fact that you come from a position where you have some authority. So, in this entire process of dealing with people, the example you gave in your presentation about the widow who was seeking her pension. So, how do you think of fieldwork like this as an exercise in the co-production of knowledge? It is not just the researcher who is coming up with knowledge, generating arguments, but also it's a co-production, which is a process of collaboration with various interlocutors, with people you interview. So how do interactions with these interlocutors, say officials, activists, citizens, shape not just what data you collect from them, but also the direction of the research itself? So would you agree that perhaps they play a dominant role, or perhaps some role in shaping the direction as well, apart from the data they're able to provide you?
Yes. So, so in an ideal case, the collaborative aspect of the work doesn't stop once the research questions are in place. It continues with the interpretation of the quote unquote data as well. So for me, that happened in two or three different ways. So even in my attentiveness to what I wanted to look at, or what I was paying attention to, um, again, engaging with activists and those who were kind of intrinsic to the introduction of these laws. And it was these laws emerged from long struggles. These were not laws that were introduced overnight by those already in power. These were often demands made of state power. These were long mobilizations of resistance against the odds. So this sort of pushed me to expand the scope of my project beyond just understanding what was otherwise what I found in the scholarship, which is the causes and consequences of exclusionary or failed programs. So most scholarship that I found, before I started this research and even today, tends to focus on how these programs fail or don't work. And this was not to necessarily provide the counterpoint, but the counterpoint, to study the counterpoint seriously, came from the political project that these movements were engaged in as they fought for some of these laws, right? Again, what I find with the kind of scholarship that only studies the sort of the reasons for failure, it often reinforces these dominant political narratives that have been deployed to actually reverse even small gains that people's struggles in challenging state power make. And us as academics and researchers, we often tend to reinforce that. So choosing to study what doesn't work versus what works, or choosing to study the politics of the possible in a way, sort of came from this early engagement with people who then became interlocutors. These were also activists that I then interviewed during the course of the study. So even in the Acevedo and Shamati piece that everyone's read, what the authors also talk about is how by engaging with your interlocutors in just the research design and developing the research questions as well, you begin to then be attentive to both, particularly in socio-legal research, to the formal and the informal, the studied and the understudied, and also what is partially institutionalized versus what is well embedded within and codified, and so that's one part of it. The other is that defending and protecting legal and institutional architectures of the rights-based approach to development, I also found was a complex challenge. So, for instance, I found myself often caught between the scholarship that was studying the failure of programs, and as well as activists and advocates of rights-based welfare who also felt that these programs were not working the way that they were intended to. So how then do you study these forums for accountability, whether they're social audits or whether there's a grievance redress law, without reversing some of the more political gains that have been made? So, for example, if you focus on how social audits are not working, or even how social audits are working well and exposing corruption within the system, or that they're not producing their intended outcomes, and this work then this becomes part of public discourse and discussions, they also play a role in then undermining some of these reforms to begin with, and that's a difficult one for a researcher to that's a difficult position for a researcher to take as well. When you try to align your research goals with the goals of movements as well. So again, not to say that this is well resolved, but one that should be attention that one should be attentive to, and one that did crop up for me in my work as well. So just to conclude, that I did want to do is to situate my findings within a longer legal and political historical context, rather than to study these hearings as sort of isolated in these moments in time, but to trace the institutional trajectory that has brought us to that point. And that's what made me attentive to sort of how there are modes of disruption that must be looked at beyond just sort of how complete resolution was, just to go back to the case that I shared. So yeah, sorry, it's a mix of things, but yeah, they're all kind of interlinked.
Thank you for those, Professor.
Thank
And we may come to that in the audience question answer segment as well. We'll now move on to the discussion on the two pieces. So starting with the Acevedo and Chamarti piece, Cultivating Attentiveness to Law in India Through Legal Anthropology. Ashutosh Ranya, why don't you introduce the piece and then we'll come to questions.
Right. So, since this was the piece which was circulated, I believe the audience is familiar with the contents of the piece. But Acevedo and Chamarthi argue in this piece that, as the professor has already covered, law needs to be understood more than just codes, laws, and statutes. And through this piece, they introduce the idea of cultivated attentiveness, which is essentially that ethnography and legal anthropology needs to be understood beyond legal institutions, say through bureaucratic practices, interactions between the grievance redressal officers and claim makers. So the first question that we have for Professor here is, so this idea of cultivated attentiveness seems to shift the focus away from mere technique to disposition when it comes to understanding anthropology. So Professor has already talked about how her identity has influences her positionality in her work. We would like to ask her whether this reconceptualization of the idea of cultivated attentiveness makes a shift when we think about a researcher's positionality. How does this idea interact with the positionality of the researcher, and can we think of it in terms of a fixed identity again, or does it also move and become a practice of attention to one's own positionality?
Yes. So again, very nicely framed question of, it's not about what we do, but how we attend is one that the question that you had shared, and it is about when do you retreat from the space to when do you insert yourself within that equation, and how does that then shape what you record, what you record, and what you interpret that particular observation to mean, and so all of that. So just again to go back to the Kulpatya Devi example, and this is where to be attentive not just to the what but the how is about for me was about taking that theater of the hearing seriously. So the hearing is not just for how arguments are weighed, but it is a mode of listening for the state, and a place where grievances and stories are of resistance are performed. I could have sat back in that very same hearing, and seen this as either as just as a performance of the state, where you have this grievance redress officer that is sort of reprimanding an implementing officer in front of this claim citizen, this this widow pensioner who's been denied her entitlement, and the implementing officer plays according to script, the grievance redress officer plays according to script, but if I did that, I would miss the very powerful statement that, or I would not take the powerful statement that Kulpatya Devi made seriously, which is when she says, "I don't lie, shoot me if you want, but when I speak the truth." And if I don't take that statement seriously, I'm not doing justice as an ethnographer or as a researcher to what is really being disrupted in that encounter, or whether there is disruption in that encounter. So even disruption did not is one that entered my kind of analytical frame because of how I was paying attention to what I was observing, and not just what I was paying attention to. So again, it maybe somebody else in my place may not have taken that statement as seriously and said, okay, this is just performative, and so be it. The resolution was less than what was desired, and Kulpata Devi still didn't receive her pension. But that she seated herself right beside a block development officer in a way that historically has never happened before, or has historically continues to be denied to most women in of her particular caste and gender background, was one that I tried to center in the analysis, in the final analysis of this as well. And I do that for multiple hearings like this. Sometimes you don't have a Kulpatya Devi that in all instances you don't have a Kulpatya Devi assert in the way that she did, but there are many such instances that I came across both in the public hearings as well as the individual hearings, where narratives or these stories, if we look at stories and narratives as vehicles of dissent, as several socio-legal scholars have talked about, they do have the power and potential to challenge and unsettle not just the status quo of bureaucratic power, but as also legal discourse of what is grievable and how it must be grieved. So that's just kind of something I wanted to share in response to your very thoughtful question.
Right. So it's not just about what position the researcher is standing at, but it's also about thinking about the practice. It's an entire practice of paying attention to these minor things that makes your research so insightful. At the same time, there's also this thought that the piece puts out that Indian legal anthropologists often remain quite engaged with the formal law because they're too mindful of how powerful it is to ever find it analytically uninteresting. Like they're always thinking that it's so powerful that it must be interesting. So, in this context of anthropology, legal anthropology, what does it mean to be mindful of law's power in socio-legal research? Because as a sociologist by training, how do you study law's oppressive capacities as well as its use for emancipatory purposes? So, are there some frameworks that move beyond a framing of law versus society, or something that weaves both of them together and helps us understand the multiple ways of using law, especially as a sociologist?
Yeah. So yes, I also think that this idea that the majestic power of the law is what often does overwhelm how we conduct research. And again, um, how what are the kinds of outcomes of interest then begin to dominate um, what we study, how we study, and what we then ultimately pay attention to as a valuable or a significant finding. Because again, I feel the majestic power of the law begins to dominate that mode of listen, or of how the researcher listens, and what the researcher pays attention to. So this is where and this is something which, for those of you who were in the law and social science class with me, we spent a few classes talking about frameworks of legal consciousness, which I find really productive. I think again, the Acevedo piece talks about legal anthropologists and legal and law and society scholars, and perhaps this is an artifact of me being a sociologist studying administrative law. I could say that what I largely study is sites of administrative law and redress. Is these frameworks of legal consciousness, which are quite productive ways to go beyond this majestic power of the law, or the power of formal law alone. So again, what does that help us do? It helps us see why people invoke the law, why people misunderstand the law, why people reject it, why people are unaware of it. So it takes us beyond the kind of, how the law works in people's everyday lives. We must use these set of questions to then break that down. And the legal consciousness literature, I think scholarship and frameworks helps us to do that. It helps us to look at both what people do and how people think about the law. So both cognition and behavior is one that I find a very productive way to think about how people engage with the law. So it's moving away from the law to think about legality, to think about a sort of what is the water that we swim in, is could be hot for some, cold for others, just perfect for others, and for someone else. So it's legality. It's not the law as fixed rules, but it's legality which changes for depending on how people what people's prior experiences have been with it, how various kinds of social conditions will either increase or decrease the propensity to engage with the law. Legality allows us to see the law as a game. It allows us to see the law as also as a product of power, and allows us to see how both culture, social, and political phenomena kind of shape the conditions under which people either resist the law, engage with the law, or entirely dismiss it. So for me, the legal consciousness literature has been quite helpful, but I'd love to hear from others um, as well as all of you, for what has worked, since this is hopefully an open conversation as well.
Right.
Thank
So
you.
I think
We'll just come to a quick discussion on the next piece, which is now about 10 years old, by Samina Dalwai, called Dance Bar Band, Doing a Feminist Legal Ethnography. Yeah.
Right. So just to briefly recap this piece for those who have read and not read as well. So Dalwai's feminist legal and ethnography in this piece is examining Mumbai's 2005 dance bar ban, showing how various political actors in Maharashtra had weaponized this sort of a discourse on morality to mask a lot of their caste gendered politics. So with her fieldwork with bar dancers, Dalwai introduces concepts such as caste capital and caste governance, showing how state has targeted lower caste women who were earning a lot of income from these livelihood sources by criminalizing the same using a lot of moral and nationalistic rhetoric. So we would love to understand a few things about this piece deeper. So in this piece, there is a particular incident where there is a police raid and Dalwai is present at that particular place. So her positionality as a lawyer, a researcher, an upper class woman, and someone who has a lot of academic capital would have likely protected her from arrest, unlike the bar girls who she was researching. So are there such moments in your field work as well, Professor, where invoking one's privileged position also becomes necessary for safety, but also risks reproducing the very hierarchies that the research is seeking to critique? So how does this affect your study and its outcomes?
Professor, you're muted.
Sorry. So, invoking one's privileged position for the necessity of safety, sometimes it does come up in fieldwork. Um, Whether it reproduces hierarchy certainly in that moment. Uh, does it does it then change the course of the research? I'm not entirely sure. And I think even in Dalvai's piece, I think the biggest thing that she does is to is to call out her position in that moment of the police raid, and by doing so, she's been reflexive about the differentiated position that she had vis-a-vis the other girls in the dance bar that would have faced a higher risk. Did that change? Did her position then alter what she ultimately writes about or what she analyzes, what she finds? I don't think so, but the reflexiveness is critical. And how you write about it becomes really important to how your work is then also read by others. So again, I mean, I've had incidents during field work where I have been staying with these social audit teams, and these are largely women from the panchayats or the communities where the social audit itself is being done. So they're largely in rural areas. These women come predominantly from more oppressed caste communities. They tend to don't have beyond a 10th or 12th degree, not even 12th, maybe 8th or 10th degree uh, class educations, and they are constantly there is a high degree of condescension when they're approaching or dealing with local bureaucrats or panchayat leaders, for example. Their work is often dismissed. There are active threats, sometimes even physical threats to their presence in the village because of the kind of power that they might be unseating by verifying public records, taking them to the public, and then having these officials putting these officials in a position where they have to publicly provide a counter, or in some cases apologies, or some cases having to admit to guilt or criminal violations, criminal acts or violations of the law. So there have been instances where those physical threats have been administered or thrown at the women that I was living with for the week that I was in a particular panchayat, including a threat that a public hearing that was scheduled for the next day, that gunshots would be fired if the public hearing was not called off. This is very real. These are not isolated incidences. These are incidences that do happen, much like the police raid that Samina Dalwai found herself in the middle of. In that case, what do you do? Do you allow for that, because this is also your part of your research? Do you now invoke your institutional position of having access to the bureaucracy? It's not just about my class and caste and urban educated identity position, but it's also my access to the institution or the bureaucracy that I had to invoke in that moment, literally to stave off a potential security threat. And that was one example where no matter how much time you had spent trying to retreat or to diminish your position amongst your interlocutors, to be able to really do the kind of participant observation you want to do, one had to invoke it in that moment um, to not allow for this to erupt.
So, Professor, as I understand, you find resonance in the piece when she says that in that particular moment, your positionality comes as a source, as becomes a resource in the process. So, I would like to ask you whether this positional privilege, which is often looked down upon in research field because it's understood as a source of bias or a source of bias or something that affects the quality of a researcher's work. But despite and beyond these momentary incidents where you have to invoke this privilege, could this positionality be considered a benefit in the sense that what if it gives you access to conversations with bureaucrats, politicians? Because in the current case, the author had social capital beyond her identity, which allowed her access to peoples in higher echelons of power and institutes. So, can it in some way be considered a methodological benefit?
Yeah, so I think it almost always is. But I think as researchers, particularly as researchers with caste class privilege, how often do we study up should be the test, or the question that we should be asking ourselves. It's almost always a benefit when you're studying down, right? When you're looking at or working with communities that don't have the kind of privilege that you bring into that situation as a researcher. So how you then use that privilege to access or to study power, and how power itself operates not just on communities, but how power operates and is hoarded, is insulated, is captured at the top, is one that we, I think, don't do enough of. And I think those are the kinds of studies that, or I mean, Samina Dalwai also talks about, and therefore opening up to the range of actors also. So, what are the institutional actors? Who are the political and bureaucratic actors that we bring into our research when we're studying the everyday life of the law, not just amongst communities that or people who have don't have privileged access, is one way to kind of, is not to mitigate, but is to use that privilege more expansively. And so that's kind of what I would say we should be doing much more of. And those are the kinds of studies that that I find really compelling, and I hope to see more of going forward.
Thank you for that very, very rich conversation, Professor and Hiranya and Ashutosh. We'll now come to questions from participants. And you can either raise your hand and Abhinav will recognize you, and you can unmute and ask your question, or you can type your question in the chat box. So, yeah, go ahead.
I think while people are thinking of questions, I also had a question. So if I can like start with that, people can type in if they want to. So I was like particularly um, going to ask you about the process where you were sitting in the these grievance redressal meetings with the bureaucrats and the people there. So I wanted to understand, what role were you playing there? Were you sitting back? You said that you talked to the person whose claim was not resolved after 2 months. So what were the person's expectations? Did they talk to you? Did they speak to you? How did they think of your role when you were sitting there? Like, I want you to understand that. For
Yes. So invariably, when you insert yourself in cases like this, even if you're trying to strictly be an observer, which I try to maintain through the entire course of the hearings. Yes, people will come up to you maybe after the hearing because they see you as some sort of a neutral or impartial outsider who might have access, right? And they see that it's marked on your body, it's marked in the way that you present yourself in that situation. So yes, people do approach you after these hearings and ask if there is a way that you can help pursue their case. Or when I follow up with when I approach them to follow up on their case 2 months later, inevitably the question is turned on me, saying, no, I have not received my pension. What is it that you can do to advance my case? That would often happen, and which is why, to the extent that was possible, I would maybe I would follow up on these cases with either looking at the website, looking at the orders, looking at matching the pension ID to look at whether the payments had been credited or there was a reason why payment had been denied, and provide the information that I could, that I had access to. And certainly if I had access to a bureaucrat either at the district level or further up that could perhaps resolve this, I would maybe pass some of those cases along. But again, as Jyotika said in the early introduction, I'm also part of an organization that does this work more systematically with state governments, with civil society organizations. So often what I would do is then I would pass these cases on to organizations that were locally based, that I had also perhaps interviewed during my research, in order to make that connection more direct, rather than me coming in and taking on the responsibility of someone's pension case when I was not going to be around in the next few months. So that's kind of a very practical, what do you do during field work when this comes up?
So related to this, I had a question as well, because I understand that you have been associated with the Social Accountability Forum for Action Research, SAFAR, and you have engaged and studied civil society organizations in general. So how do you find the research that a sociologist may do differ on the basis of whether they are an individual sociologist versus when they have access to these connections, access to a team which works together as part of, let's say, a non-governmental organization or civil society in general? How do they shape the research and perhaps provision of public services?
Yes. So while doing the research, I was not, I was doing the research, I mean, individually in that sense. But again, going back to the design and the identification of the research questions, emerge from deliberations with collectives, campaigns, and just being part of those conversations for many years. So that part of the research design came from a more deliberative collective process, but the actual the conducting of the interviews, the actual observation, all that, I mean, I did as an independent individual researcher. But then again, also sharing findings, presenting your work in audiences that are not that are academic, but also non-academic audiences, as well as sharing your work with your interlocutors, is also a good way to enhance and to deepen your own interpretations of what you're hearing, what you're observing, and also attributing accurately the the frameworks, the cognitive frameworks that you have identified when you hear back from the interlocutors that you've worked with or that you've spent time with. So in that sense, there is a collective deliberative process at the beginning, and then at the interpretation stage. But of course, the actual act of seeing the process through is still one that is has an element of loneliness, which is part of all research, and it's actually what makes for good, I think, productive and constructive research as well. Some distance is extremely critical as well.
Thank you, Professor. I think there's one more quite related question in the chat by Avantika. Avantika is asking, if do people affected expect you to intervene and help with the grievances? So I think you covered that a bit, but if you could address that again.
Yeah, so I think I answered that in response to your question as well, Abhinav, that yes, there is that expectation sometimes, and again, you can't fulfill that expectation when you're doing research, and so again, going into any kind of field through or having organizational contacts of people who are local, who will continue to be there after you have left, is really important. And to not take on, or to not sort of set the expectation that you will pursue someone's individual case unless you really can do it, is important. So yeah, so I think I kind of answered that in previously as well.
Right, thank you. Abhinav, are there any more
Yeah.
questions in chat?
Yeah, there are 3 more
Yeah.
questions.
Yeah. Okay.
So the first question is by Ishita, and they have clarified that the question pertains to the motivations and mindset. And they have asked this as someone who's just beginning to explore the idea of getting into academia. The question is, what are the many layers of identifications and lenses does any researcher in general need to possess to make the research more personal? Does it at any point become abstract and intangible to be able to comprehend and structure? And if yes, then how do you bring yourself back to it?
So I think again, being motivated, again, come back to the research question and where do they come from? So, you should be motivated by your research questions in ways that can firstly keep you at it for sometimes what can be long lengths of time. And if you're out doing field work, they can put you out of your comfort zone for lengths of time. And so being motivated by your research question is what makes the research personal, firstly. Does it become abstract and intangible? Yes, and sometimes it's necessary. It's the necessary distance that one needs to also maintain in order to be able to again, you're a participant. Just for instance, just the method of participant observation, where you're embedding and immersing yourself in the context that you're studying, but you're also adopting a lens of an observer. So that's, I mean, that apply, and you can extend that out to thinking about the kind of bigger pieces of your research, but also how you do your research. So this kind of one arm's distance of being immersed and embedded, but keeping your observer hat on, or your observer lens on, is what makes for it is what makes for good research, and what makes for credible research, what makes for research that is analytically interesting, analytically powerful, but also one that is but one that is reflexive. And so I think bringing the personal into your analysis is usually what method sections are for, and they're really important to take very, very seriously in terms of identifying your positions, not just your positionality, but also why you chose to do the kind of the research that you do, and why you choose, what your interpretations are also informed by. It's not just the scholarship, but it's also how you may read with the grain or against the grain, and why that is the case or why it's not the case. So these are additional questions to ask of yourself as you uh, when you're at the writing stage of your research. So I wouldn't worry about whether your research is becoming too abstract from you when you're starting out. But it's a question that you should keep pushing yourself to ask as you traverse that trajectory of the research project, whether it's a doctoral work or a master's thesis, or whatever piece of research that you choose to undertake.
Thank you so much, Professor. There are 2 more questions. So the second is by Meher Pandey. They have asked, do you think participatory governance exposes people or claim makers to new modes of disempowerment? Do you think the woman who was able to raise her voice against the block development officer may be an exception, because sitting in a closed room with officials can be scarier in a different way?
Meher, do you want to say a little bit more about what you mean by scarier in a different way?
So the video, pushed back at her when the grievance officer said that, I don't remember exactly what they said, but they said you didn't come in the beginning. Why didn't you come? So these kind of questions about um like you're too late, it can be very confrontational, and you need a certain kind of person to be able to push back in
Right.
that situation. Do you think
Yes.
It makes it very individual?
Yes. Yes. No, thank you for that question. And I think absolutely there can be multiple ways to think about that encounter. And I'm not saying that what I presented here is one that is the only way to think about that particular encounter, but I'm historicizing in a way. I'm putting Kulpatya Devi's case in I'm looking at it long arc of what is Kulpatya Devi's encounter a case of. So I'm trying not to see Kulpatya Devi's case as an exception or as just an individual case that is specific only to her, because one is that I have observed flashes like Kulpatya Devi's statements in multiple hearings, and I refer to that in the longer, the broader work, and I'm connecting. And so you're obviously also looking for these patterns, which is that when you're seeing these flashes of resistance, of rage, of articulation with a certain kind of sharpness, what do these really mean, and what do they amount to, what are they a case of? So what they might be met with is backlash, and that's very real, and I do talk about that in other instances of hearings where um, raising your voice like that might result in sometimes even fatal backlash. And we do have, I do talk about in the broader work about backlash, which in some cases of RTI users, RTI people who've asked for RTI, just mundane information around pensions, for example, have been killed for asking questions, right? We know this. So it's the backlash is very real. But if we flip that, despite the backlash being very real, we see persistent, we see this persistence in the raising of voices in forms that we have not heard before, because we've not taken the hearing or the narratives in the hearing seriously enough. So that's kind of the quest here, which is that what are these what we would otherwise have dismissed as just flashes in the pan of a broader system that is so arbitrary, discretionary, so oppressive. How do we treat these flashes in these flashes? What do we call them? What are they disrupting or not disrupting? And those are the kinds of questions that I'm trying to ask and trying to draw connections between. So I don't see Kulpatya Devi's case as an exception, but as one that is making us attune to forms of actually assertion, at the same time being attentive to the very real possibilities of backlash.
Right.
Thank you,
Thank you.
Professor. There's one more question by Nachiket. Nachiket is asking, is there a risk of being too sociological for lawyers and too legalistic for sociologists? How do we find a middle ground that satisfies both disciplines?
I think this is the forum for, I mean, anyone could weigh in on this, really. The risk of being too sociological for lawyers. So what do the lawyers or the lawyers in training think in this forum? It would be interesting to hear. But I think I can maybe try and answer what does it mean to be too legalistic for sociologists, which is that, again, taking the law too seriously is one that I think sociologists tend to, I think that's the problem that I have faced in where people have pushed back against the research to say that, okay, you're taking these forums, perhaps too seriously. So again, how then do I mean, these are forums that are mandated by law. These are institutional architectures that are resourced and exist at scale across the country. And there are legal mandates, but there are also bureaucrats sitting in these offices and positions, adjudicating cases like this every day. And to me, they fall, yes, they're quasi-judicial in a sense, and we can get into kind of the legal, the actual law, let's say the grievance redress law and where it falls. They are, you could see them as alternative dispute resolution forums. You could see them as akin to the tutela system in Colombia, or you could even see them as somewhat similar to the South African Constitutional Courts dealing with cases of health and housing rights, for example. But sociologists who study the state, for example, and this comes up in the piece that you all may have read as well, which is that how do you distinguish the anthropology of the law from anthropology of the state? And so I think work like this would perhaps fall a little bit between those two, which is that are you studying the state or are you studying the working of the law and its competing and its blurred boundaries and its competing meanings in people's everyday lives, um, and that and it's a more fruitful endeavor to study the state than to study the law. Would be something that would be a pushback that I've got in some forums. Um, so yeah, can you find a middle ground that satisfies both disciplines? I think that's exactly what good socio-legal research is doing, and I think the kinds of readings that are on the list here and the kind of work that the SLR journalist is publishing is exactly that kind of work. So yes, so I hope that this inspires more of you to do this work that hits that middle ground between the two.
I think Divya has something to add, and Ishita has added that I do think one is always an outlier. So maybe they are trying to weigh in on the question. But Divya, yes, please go ahead.
Hello. So, actually, my question was around the fact that here also much of the discussion has been around how a research, socio-legal research positionality is through ethnography, interviews, etc. Basically, like keeping yourself there. So, like, how do we meaningfully account for positionality when let's say our primary site of analysis is judicial reasoning, legal texts, or doctrinal archives rather than any lived field work?
Right. So, I mean, I am largely speaking from the kind of methodological background that I have in terms of because I am trained as a sociologist, so I'm looking at certain kinds of qualitative research methods and bringing that to bear on looking at institutions which are legal institutions and legal infrastructures. And so I use the kind of methods that I've described here. But again, judicial reasoning, I would say, even to look at judicial reasoning, you have to have a site, right? You have to situate yourself in a particular, whether it's a courtroom or whether it's a grievance redress hearing chamber. It's how you then observe that, if you were to apply an ethnographer's lens, it's how that reasoning plays out, and so your attentiveness to narratives and counter narratives becomes then again another way of where the method comes to bear on the object or the thing that you're studying, whether it's a site, whether it's a text, or whether it's modes of reasoning and argumentation, and the same with text material as well. So, for instance, in this work, I do look at the actual grievances filed, the interim orders, the final orders that are written, and these go into hundreds and hundreds of pages as well. They're not obviously they're relatively brief, but even the modes of reasoning encoded into those orders do inform what one then pays attention to when one triangulates and looks at the hearing itself. So the hearing, the text of the grievance and the orders, and then what you observe are sort of three-way, or the interviews that you do with people who enter the complainants or the claimants who enter this hearing process, then becomes the kind of way that you triangulate in order to identify these outcomes that are not just about resolution, but about how power is shaped or reshaped in that encounter. So yeah, I'm not sure if that answers your question, but that's the kind of method that I'm trained in and I use, so I spoke to.
If I can just
Thank
add
you.
to that, I think one way of looking at doctrine and judicial reasoning is again a method that comes through, I mean, broadly in say say subaltern school studies onwards, or in like the broader law and society movement, is method of reading against the grain. So even in the way one reads a judgment, that there is a way of reading closely, reading between the lines as to where one places that in a broader socio-cultural, historical, political context. And I mean, representative pieces that do this kind of work. So, for instance, SLR recently published a piece by Danish Sheikh and Rupali Samuel on the Suprio judgment, so the marriage equality judgment, which is in the form of epistolary engagements, exchanges between the two of them. So, in the form of letters, in which they are really discussing the politics of marriage equality and what it means for this rights-based claim for queer rights through the language of the law and the court means. And it's not doing like a like a standard doctrinal review of the superior judgment, but it's really turning a socio-legal eye towards it. So I would recommend a piece like that. I think it's also useful to locate judicial actors, so judges, lawyers, politicians, etc., and litigants themselves in broad social context that they inhabit. So for instance, that there's been very good journalistic pieces, particularly in the Caravan, which look at law and politics recently. So Saurav Das's piece on the legacy of Justice Chandrachud, as well as the RSS legal wing. Those are a couple of pieces, again, from the context of journalism, which are speaking to some of these concerns. Or the series of pieces that Gautam Bhatia usually posts after the tenure of each Supreme Court judge, retiring judge, ends, on where one can place their jurisprudence in a broader context of the positions they inhabit and so on. So these are a couple of places I would recommend turning to. And point being broadly, I think reading against the grain, and treating judgments as not merely doctrine, but representative of broader social contexts of the writers and people engaging in these processes as well. I think those are a couple of ways of thinking about this.
Thank you. If there are no further comments and questions, I think you can proceed, Jyotika.
Okay, thank you everyone for those questions. So we just want to quickly address where SLR is broadly in a network of various other publications, platforms, and conferences that are available for engaging with social legal work and potentially publishing your own work. And just to make references to a couple of journals who are doing very interesting work, which we recommend that you have a look at. These include Law and Social Inquiry, the Journal of Law and Society, Social and Legal Studies, the International Journal for Law and Context, as well as the Journal for Indian Law and Society, which has been around for quite some time. And blogs, which are generally more accessible for early career academics and students. We recommend the Square Circle Clinic, which used to be called Project 39A. Their blog, which publishes excellent work at the intersections of criminal law and interdisciplinary work engaging with it. Frontiers of Social Legal Studies, which is the blog of the Oxford Center of Social Legal Studies. Again, published pieces across various kinds of formats and disciplines, but another interesting place to look at. The SLSA blog, which is the Social Legal Studies Association. Law and Legal Studies, which is again the journal. They also have a blog, as well as Law and Other Things, which is based out of Nalsar. And some platforms and conferences which are worth engaging with, looking at the kinds of things that they are publishing, organizing. Law and Social Sciences Research Network, or LASNet, which of course many of us in India are more familiar with, which has been around for a while and has done very, very interesting work, and really built this community, this large community of scholars who are working at the intersections of these areas, as well as the Law and Society Association, which is based out of the US, and the Socio-Legal Studies Association, which is primarily based out of the UK. Just to say that SLR finds itself in really this broad, disparate almost community of places, publications, and platforms which are trying to engage with this conversation. And we think it is very productive that people interested in this kind of work also look at what they are publishing, what kinds of conversations are happening in the field. I will now just hand over to Abhinav and Chahat, the Deputy Editor-in-Chief Journal and Deputy Editor-in-Chief of the SLR Forum, to explain a little bit about the submission guidelines and process for SLR itself.
Thank you so much. So just on our submission guidelines, I think Jyotika covered a bit about our aims and scope and how we publish and look for interdisciplinary research that critically inquires into the intersections between the law and the social science. We particularly focus on the South Asian context. And you can find more details about our submission guidelines on our website, which is repository.nls.ac.in/SLR. We usually accept our submissions for the journal through the Digital Commons platform. Again, the link is available on the website under the tab of submission guidelines. And we publish articles and 3 other categories. So articles are general standard articles with a particular research question ranging from 5,000 to 10,000 words. Notes from the field is particularly innovative because we look forward to publish works from practitioners and researchers about their insights and observations from research that they have conducted in the past or they are currently conducting. Case legislative comments and book reviews are quite self-explanatory, but we look forward for insights of the authors and not just summary, and how the particular case, for example, again, as Jyotika discussed, the Supriyo case particularly falls within this context of law and the social sciences. Yeah, I think that's it. I'll keep it short. Chad, do you want to go ahead? Yeah, so editorial process, let me just cover this first. So the editorial process for the journal piece, it has 3 stages. So the first round includes 2 stages. First is a simple desk review that is conducted, and we just look if the piece broadly falls within our mandate as clarified in our aims and scope on the website, and whether it is something that we can publish. After this, we send it to the editors for review. We ensure that anonymity is maintained in this process and the editors do not know about the identity of the authors. The editors give their comments, and this process takes around 2 weeks, after which we convey our decision to the author if we are deciding to reject the piece at this stage. But if we decide to accept this piece, we send it to the faculty board and peer reviewers for their comments and their decision. Again, we ensure that anonymity is maintained in this process. And it usually takes around 3 to 6 weeks, depending on the availability of the faculty board and the peer reviewers. And they take, again, their decision to accept or reject the piece and give back their comments, which we forward to the author, along with the editorial comments by the editors at SLR. After this, we send all these comments back to the author, and the author may decide to accept some revisions or reject some revisions. We also copy edit the piece in the 3rd stage. And this again takes around 4 weeks, depending on the availability of the author. And after this, we publish the piece. Thank you, I think, Jyotika. Chahat, you can proceed.
Hi everyone, I'll just quickly cover the submission guidelines for the SLR Forum. The SLR Forum is the online companion to our in-print journal. And as you can see from this picture, this is what the website looks like. It's different from the journal in the sense that there's a diversification of the kind of content that we publish on the SLR Forum. So there's a bunch of book roundtables that we publish author interviews. There's also a focus on practitioners in terms of voices from the field, and it's not just restricted to academicians or scholars in that sense. Apart from that, the forum is also envisioned as a space to sort of ensure timely and accessible discourse, particularly on contemporary issues. And we imagine this as a more throughout the year kind of rolling submission as opposed to the SLR journal. In terms of our vision for the SLR forum, apart from diversification of content and a wider scope of potential authors, another thing that we emphasize is there's a particular emphasis on series. So the forum does short form content on a particular topic. So for instance, submissions. In the past, we've done series on law and emotion, law and film, etc. stuff like that. And in it, so basically, series are like tailored content to a specific area or a specific niche of social legal intervention. The editorial process for the forum is similar to the journal. We conduct double anonymized reviews and revert with editorial comments at the end of 2 weeks from the date of submission. In order to submit to the SLR forum, instead of using the digital commons, you can directly email us at sociallegalforumreview@gmail.com. Um, so now we'll just quickly go over what editors on our board look out for when we're reviewing editorial submissions. The first thing and the primary thing that we look out for, which is our first level of inquiry, is whether the piece fits our aims and scope, which is the mandate of the social legal review. As we've discussed throughout this workshop, the mandate includes an understanding of law in the social context, so law at the intersection of social scientists. And more often than not, we have had to reject pieces that have really insightful legal analysis simply due to the fact that they don't contextualize that or ground that in a social context. Another important thing here is that the social legal intervention must not be cursory to the sort of analysis that the piece is undertaking and must be central to the kind of submission that you put forward either to the forum or to the journal. Yeah, Abhinav, do you want to continue this?
Yeah. So the other things that the editors look out for is whether the thesis is clearly stated, it is novel or not, if the piece has a particular roadmap which they have clearly explained, especially when it comes to long form journal articles. If the piece is properly referenced and there's a good literature review, they have the inferences drawn from this are very clear. You can also find more details on the style guide and our citation style on our website again. We also look for if the arguments flow structurally or not, if they make sense or not, if the inferences that are drawn are not completely simplistic and have an element of the author's own understanding and voice. If they're thoroughly engaged with other papers in the work, with the roadmap that they have constructed, and if the piece has a particular conclusion, and if they've clearly explained their arguments and not introduced something new in the conclusion itself. If you could move to the next slide, Jyotika. Yeah. So these are some other points. So particularly, we find that a lot of we receive some comparative analysis, but the rationale for the jurisdictions that are identified, or even in some sense to cases that are identified, is not clearly explained. So that is something that we look for if the rationale is clear or not. Then again, the critiques should be more institutional and socio-legal and not particular to the intent of the judges or the legislators. And if there's a proposal for a policy reform or a legislative reform, we ensure, we look for whether it is completely doctrinal or not. And if it is, then we do not usually publish the piece. And whether it again falls within the intersection of the law and the social sciences. And if such a proposal is feasible or not, and if they have particularly engaged with it and not just introduce it towards the end as a conclusion, because we are not a policy paper as such. That's it from my end, I think. Jyotika, would you like to add?
Yeah, thank you so much, Abhinav and Chahat. If there's any questions with respect to what we said about submissions, editorial policies, happy to take those. Otherwise, I think we can conclude. And in general, for any questions that you may have about submission policies, or we are often very open to taking pitches before the author submits the final piece itself, and we try our best to offer an understanding of whether a certain pitch would fit our mandate. You are more than welcome to email us for both the forum submission as well as the journal. And I would just want to mention that our call for papers for volume 22-1 of the journal, which is a generalist issue, is currently open, and the deadline is at the end of the month, 31st of January. And also just to introduce our next issue, which is a special issue on law and history in South Asia. We will soon release the call for papers for that, and the deadline will be the end of March this year. The first issue is due to be published in July of this year, and the special issue will be published towards the end of the year, which is somewhere around November, December this year. But if there's no further questions, then I would just like to conclude on behalf of the editorial board. And firstly, thank you so much, Professor, for taking your time and engaging with this theme and the mandate of our workshop so thoughtfully and bringing your incredibly rich insights from your ongoing research and the book project. So thank you so much for your time and for participating in this. And thank you so much to our editors who joined and helped us moderate the session, Hiranya and Ashutosh, as well as all the participants for taking out 2 hours of their Saturday morning and joining us. Thank you so much. And we will conclude here. Bye bye.
Thank you all. Thanks so much.
Thank you.